start the next session.
My name is Nicolai and on behalf of the organizers and the Danish Institute of Athens, it's my pleasure to introduce today's keynote speaker, Professor Barbara Keyes. Barbara Keyes is an associate professor of history at the University of Melbourne. She works on 20th century international relations, US foreign relations, US history, and a global perspective of the Cold War. She holds her PhD from Harvard University, and in 2006 she published her first book on globalizing sport. And then her second book was published in 2014 on reclaiming American virtue, the human rights revolution of the 1970s. Today, Professor Keyes will speak about torture in law and public opinion before the Greek case. The floor is yours.
Well, thank you to the organizers for having me. Thank you. It's such a great pleasure to be here at such an important conference on such an important topic. I'm going to talk today about a Greek case, but a different Greek case than the one we've gathered to discuss. Our Greek case, the conference one, is sometimes mischaracterized as the first interstate petition brought under the European Convention of Human Rights. I'm actually going to talk about the first case that was the first interstate case, which was brought by Greece and not against Greece. And it was brought in 1956 against the United Kingdom over its Cyprus colony. It was a key moment in bringing the European Convention system to life. At a time when the Convention system had very little work to do and when the form that it would take in the life of Europe was still very much up in the air. So the European Commission had only held its first session in 1954 and only established its rules of procedure in 1955. Looking at this early case, I hope, will help us contextualize what was unique about the later Greek case, and I think is particularly important in helping us chart the evolution of the norm against torture as it shifts through the landscape of what Europe stood for and against. There's some notable similarities between the early case brought by Greece and the later case brought against Greece. First of all, they both comprise two distinct cases, and in each, the second dealt with claims of torture. They also both involve questions about Article 15 and emergencies that justified, that threatened the life of a nation, justifying derogations from the convention. Third, the Greek case about torture resulted in a finding against Greece, marking the first time that an international human rights body had concluded that a state had practiced torture. However, the case in the 1950s almost certainly would also have concluded with findings of torture, or at least of violations of Article 3, if it had not been terminated, thanks to the political settlement in Cyprus. And finally, both cases involved thorny questions about how to prove that torture had occurred, and where to draw the line between torture and inhuman and degrading treatment and punishment. Both of them equally prohibited by Article 3, but somehow the distinction between the two becoming increasingly important in this particular case. Because it was launched in the 1950s, the Cyprus case was marked much more deeply by decolonization than the later Greek case. The backdrop of the controversy of the French war in Algeria loomed particularly large. Now, the efforts that Greece made to hold the UK accountable for human rights in Cyprus were focused above all on the right to self-determination. Charges of torture were a means to the end of independence, or indeed gnosis, for they were meant to show that British colonialism in Cyprus lacked legitimacy. Now, the case involved a number of different allegations, including violations of freedom of the press, assembly, punishment amounting to inhuman treatment, including collective punishment, collective fines, curfews that prevented entire villages from tending to their fields and shops. In deciding what violations to label torture as distinct from other kinds of inflicted suffering, the case would help establish lasting ideas around the legal definition of torture, which of course is not defined in Article 3. And the public and the legal reactions to the charges of physical brutality that became widespread around Cyprus allow us to see changes in European ideas about the legitimate uses of violence. I'll draw out a number of themes. First, the line between legitimate and illegitimate uses of violence and the line between reasonable and unreasonable treatment is not bright and clear. It is fuzzy and shifting. What today might seem to be widely agreed on notions of torture have evolved in a contestation between what happens on the ground, what governments do, and public opinion and legal reactions to those practices. So today, for example, there's considerable debate over whether capital punishment, corporal punishment, and solitary confinement for long periods of time can or do constitute torture. We saw already this debate in the question and answer session yesterday. In the 1950s, before there was international case law clarifying definitions of torture, the word was often used interchangeably with cruelty, barbarity, and brutality. Both the British and the Greeks contesting the Cyprus case had difficulty settling on precise parameters for what torture was and for distinguishing it from its close cousin, inhuman and degrading treatment and punishment. So this means that debates over torture are often especially useful proxies for seeing why and where international and national norms about the legitimate use of violence and physical coercion are shifting. And in particular, I would suggest that we begin to see in the Cyprus case an evolution in which torture begins to assume a position of supremacy as a human rights violation of unparalleled program. The second theme is that British authorities in Cyprus and elsewhere used terrorism to justify brutality. Although the response to the charges of torture was naive and appears today to me strikingly smug and arrogant, the UK helped establish a pattern followed to this day in which governments almost always justify brutal techniques as necessary in the particular context of terrorism, while denying that they are doing anything that actually constitutes torture. And finally, a third thread is simply that there's a common trend among governments, particularly in the West, that they create and sign on to international human rights instruments primarily for export and not as constraints on their own behavior. And as with the UK, in 1956, it takes them by surprise when they're asked to adhere to these instruments that they promoted. I will sketch out the background here very, very briefly because I suspect it's not necessary for this audience. I'll just note that the Cyprus question was a very important part of Greek politics in the second half of the 50s, and that both the Greek Cypriots and the Greek government chose internationalization of the cause of Cyprus independence to push their claims, very much along the lines of what the Algerians were doing at the same time. And internationalization meant pursuing claims at the UN, at the European Commission, and in the press. The backdrop for these campaigns was the so-called emergency in Cyprus that began with the outbreak of AOKA-led terrorism in 1956. AOKA, the Greek Cypriot nationalist guerrilla organization that aimed to bring an end to British rule in Cyprus and achieve gnosis. The insurgency in Cyprus was met with harsh repressive measures by the UK. But eventually the UK did reach a political settlement over independence for Cyprus, and that is what stopped the case against torture, the second application, from reaching a conclusion. I'll note that several excellent studies have explored this broader picture already, including works by Brian Drowan, Robert Holland, Brian Simpson, David French, and others. I supplement those rich studies with my own readings of UK government documents. There are a few Australian government documents that are talking very closely with the British parliamentary speeches. To a limited extent, Council of Europe documents, because I haven't been able to find the full record of the Cyprus case in the Council records, but also press reports in the UK press and translations of Greek press reports in the UK documents. And my aim, again, is to draw out the particular role played by allegations of torture, which becomes central to the larger struggle over the future of Cyprus. And I argue that the Greek efforts to focus attention on physical and mental cruelty by the UK worked in similar ways to the later Greek case to discredit British colonial rule in general, in particular by undermining the civilizational claims that it was based on. The violence that the British wielded in Cyprus was absolutely routine, perhaps even less egregious than in other British colonies. But Cyprus was part of Europe, and this very strongly gave the Greek critique traction. In other words, civilizational hierarchies made the Cyprus case stand out, along with the fact that information was very easy to obtain from the island. Indeed, this was a factor that played out in the Greek case as well. Let me very briefly address the question of the extent to which the UK used torture in Cyprus as an instrument of state policy. It's impossible to answer the question precisely. British scholars tend to note that AOCA had every reason to exaggerate claims of mistreatment. On the other hand, it's clear that the British believed that getting information was a priority, and they were unwilling to hamper efforts to get it. As was and remains typical, British officials used euphemisms like questioning of unusual rigor to conceal from themselves and from others that they were, in effect, condoning torture. And if we look at an early 1957 report from an ICRC, International Red Cross representative, who investigated by interviewing around 60 prisoners, he heard stories of beating, burning, immersion in icy water, and waterboarding. He testified to seeing himself broken jaw, cracked ribs in great number, broken fingers, broken wrists, injuries to the skull, blows of a bayonet in the back, traces of whip marks on the back, traces of burns on legs. He interviewed Nico Sampson, who was missing fingernails and had burn scars on his legs. And his report noted that the official explanation given for Nikos' losing his nails is that police had to hit his hand when they were trying to disarm him during his arrest. More recently, other former prisoners have been interviewed in connection with the suit against Britain for torture, such as Petros Petrides, who said that he was stripped, punched, waterboarded, and claimed that they put a metal bucket over his head and beat it. He says he's still deaf in one ear from that experience. And there was the use of stress positions. So, although it was not mandated as official British policy, it was what we now consider to be forms of torture were in relatively widespread use in Cyprus. I want to begin with one of them that was clearly legal. When the incoming governor of Cyprus, who was sent to take charge during the emergency, Field Marshal Sir John Harding, came to Cyprus, he immediately asked the British cabinet for harsh measures to be implemented, including a law allowing him to whip boys under the age of 18. Prime Minister Anthony Eden hesitated, knowing that it would be a public relations problem. The cabinet agreed that the measure was necessary, but implored Harding not to use it in a wholesale way. So whipping was therefore a legal punishment for boys under 18 who were convicted of violations such as unlawful assembly, taking part in unlawful processions, or disorderly conduct. The maximum number of strokes was 12. They were inflicted by a light rod or cane or birch. As Brian Simpson notes, that this particular picture, which is in the archives of the British Foreign Office, that was sent by Cypriot authorities to say this is the kind of instrument that was used, and he notes that this is probably the least offensive looking instrument that they could find to show. It's true that there had to be a doctor present who certified the boy as fit to be whipped before the whipping occurred. Now, when Greece brought its first complaint in 1956 to the European Commission, and also when it raised these issues at the UN, it brought up the cases of whipping. And its intent was to suggest that whipping children was outside the bounds of civilized norms. So the 1956 complaint to the European Commission included this sentence: though the United Kingdom may still think fit to inflict this punishment on its colored subjects, in no circumstances can this practice be tolerated in countries of Greco-Latin culture, where it was long ago abolished as degrading. And this language underscores a central theme in the Greek campaign over Cyprus. They spoke of standards of civilization that applied to Europe and that differed from the standards that applied elsewhere. These were not universal human rights, these were European human rights. And relatedly, the fact that Cyprus was in and of Europe was used to make the case that punishments that might be acceptable elsewhere were not acceptable there. And in fact, the consensus against corporal punishment was new even in Europe. It had been abolished in 13 countries that were members of the Council of Europe. Whipping had only been outlawed in England and Wales in 1948. And I understand that corporal punishment was legal in Greek schools until 2005. In their internal discussions about how to publicly defend the practice of whipping boys, UK authorities made much of the fact that it was still then an entirely normal practice at private schools in the UK to beat the children of the rich and privileged elites. Yet they also recognized that cultural context mattered. Beatings were accepted by parents and by children in English private schools. But parents and children in Cyprus saw these beatings as humiliating and degrading. Indeed, humiliation was part of the point. And UK officials also recognized that severity mattered. So when they rushed to do a worldwide survey, sending out telegrams to all the different foreign embassies around the world saying, please tell us what your country does about corporal punishment, they asked for specific details. What kind of instrument was used? Was the victim clothed? What medical precautions were taken? The Colonial Office response was particularly defensive because, of course, this practice was widespread in the colonies. And they noted that whipping, which they pointed out was not carried out by a whip. Indeed, they briefly debated changing the legal terminology to caning, which would be more accurate, but decided that it was so pervasively used that it would take far too much effort to change the term. Whipping, they said, is a mild and humane treatment, and Her Majesty's government believes that its use in recent months in Cyprus to deal with a very special kind of case has been wholly salutary. If anyone can think of a better, more humane, and more effective treatment for these youngsters, we'd be glad to hear of it. So they actually defend whipping as, or caning, as humane. And it's not a surprise since corporal punishment was widespread. It was used in British colonies in Nyasaland, Nigeria, Trinidad, the Falkland Islands, Kenya, Tanganyika, Somaliland, British Honduras, British Guyana, Northern Rhodesia, Hong Kong, and elsewhere. Now, while whipping boys was one of the issues Greece raised in its campaigns, and which helped to inflame public opinion against Britain, it later clarified that it did not intend to suggest that whipping was a form of torture. So let me turn to the more specific claims that as this case goes along, the Greek government claims to be actually torture. And there were two prongs that I'm going to cover. The first happens at the UN, and the second then is at the European Commission, where Greece is trying to get international bodies to condemn British rule in Cyprus. And the information that they're relying on, let me note, is coming from so-called human rights committees in Cyprus. These are formed by lawyers who go out and investigate, document, and then file complaints with the British authorities about abuses. So much of the information that we have about these abuses is coming from these human rights committees. And already in 1955, drawing on this kind of information, after the British had introduced emergency measures in Cyprus, Greece asked the UN for the first time to take up the question of Cyprus, including torture. The request stated that the suppression of freedoms and elementary human rights is in disregard not only of the letter and the spirit of the UN Charter, but also of all legal and moral standards of the civilized world. And at that time, the Greek Foreign Secretary gave the UN Secretariat a confidential file containing 237 allegations of torture by British security forces. However, the UK was able to prevent the General Assembly from taking up Cyprus in 1955 and 1956. It was then in 1957, coinciding with the height of concern over the situation in Algeria, that Greece succeeded in getting the General Assembly to take up the question, or inscribing this in the agenda. The initial language that the Greek government used charged the UK with violating self-determination and, secondly, with violations of human rights and atrocities. In oral arguments, the Greek Foreign Minister, Avarov, claimed to have unimpeachable evidence that hundreds of Cypriots had been tortured. He cited the names of at least 2 specific torturers and gave details of some specific cases. A later Greek speaker claimed to have personally known a great number of torture victims. In these debates at the UN, the use of the word atrocities is even more common than the use of the word torture. And it harkens back to the record of Nazism, rather than to the specific legal language of the post-Nazi international human rights instruments. So the Greek government, for example, said that it had in its files some 500 signed testimonies substantiating accusations of inhuman practices, brutalities, and atrocities. These vague terms were lumped into a single basket. Now also, in a context in which the norm of state sovereignty over internal affairs was still very strong, Greece also made the case that this matter was relevant to the international community, and the international community was obliged to consider it because these constituted crimes against humanity, offering a challenge not just to the UK, but to the international community. So the Greek petition to the UN stated that inhuman methods do not belong to the era of the UN. Greek representatives talked about respect for human rights as principles for which all mankind fought and suffered in the war against Nazism. And they claimed that British actions in Cyprus raised political, legal, and moral factors of concern to the UN. Now the British, not surprisingly, fell back on Article 2, Section 7, that the UN should not involve itself in the internal administration of member states. And the British representative warned that if the UN were to start to involve itself in matters of internal sovereignty, it would have incalculable consequences. He said, any disgruntled faction in any country which could procure the services of another power to aid and abet them would be able to bring a case at the UN against their own government. He said he wouldn't even deign to address the charges of torture. They were so ludicrous, except to say that the UK's known reputation in the conduct of colonial affairs should in itself be sufficient refutation of charges against the regime in Cyprus. Although he did acknowledge one or two cases where people overstepped the mark. Surprisingly to me, at least, these arguments won considerable sympathy at the UN. And in the committee debates preceding the General Assembly vote, most countries, including Norway, which is the only one involved in the smaller committee that preceded the General Assembly discussion, most countries seemed willing to defer to the quote-unquote political wisdom of the UK and to prefer not to get involved in complicating its difficult task of administering and working toward the independence of colonies. So let me note that in the Greek press, reports of British brutality had circulated almost since the start of the emergency. And central to these complaints, indeed, almost universal, was the claim that these were like Nazi atrocities. Still, of course, fresh in the mind of Europeans in the 1950s, and particularly emotional in Greece, which had suffered greatly during the Nazi occupation. So, for example, Ethnarch Makarios, the leader of the Greek Cypriots, told the New York Times in February of 1956, "Sometimes the British have used methods that were not far from things I experienced during the German occupation of Greece." A Greek newspaper in 1957 said in a typical formulation, "One would think that one were reading a list of tortures perpetrated in a German concentration camp. Those who committed such abominable acts under Hitler were condemned by the Allies. But the British, who are now employing the same dreadful methods of torture, sit side by side with representatives of other states on the Committee for Human Rights and are considered pillars of humanitarianism." There were many statements that there was enough to launch something like a set of Nuremberg trials. So Ioka, for example, claimed to have enough information for trials similar to those at Nuremberg. Now, how were these claims substantiated? Because this is such a thorny problem to prove that torture has happened. What the Greek side produced were individual signed testimonies in the handwriting of and signed by victims, physical evidence, sometimes medical certification, which was often hard to get, but sometimes also just that the accusing person had seen evidence of scarring. So Makarios said at one point, "I examined personally the marks a former prisoner had on his body. He said he had been beaten by a heavy piece of chain." And finally, the consistency across stories about the techniques that were being used, and also, in certain cases, a repetition of particular names of torturers. So I'll come back to the issue of proof and credibility in a few minutes. But the British strategy in response to this press campaign, the campaign at the UN, and eventually to the complaint at the European Commission was to deny any systematic ill treatment, and indeed to pour scorn on the very idea that British officials could even be thought to be capable of torture. In the UK, the conservative side of public opinion was strongly in favor of British use of harsh measures to combat terrorism on the island. And in one late article from the conservative press, for example, it reports on the indignation in the army and the undermining of the morale of the security services that these complaints have been litigated. And it says that in one case, an officer who had threatened a Cypriot advocate with a revolver and had been rude to him was made to apologize and severely reprimanded. So, in other words, when there were these very minor cases of people overstepping the bounds, they were punished. But left-leaning public opinion in the UK was more inclined to believe the charges of brutality, although they often were quick to note that they were no doubt exaggerated, but had a kernel of truth to them. So reports appeared in the British press, for example, in which journalists claimed that British security forces had admitted to brutality and justified it. So one journalist wrote that more than once I've asked British police officers bluntly whether prisoners are beaten up. They reply, wouldn't you, after what they have done to us? This journalist went on to say that I have heard British paratroopers recount with relish instances of what they called mild third degree, used to extract information during anti-terrorist operations. And they always justified their actions. They are murderers, and we need information. A few members of the opposition Labour Party took up the cause of Cyprus and visited and interviewed AOCA prisoners, concluding that there was prima facie evidence of torture. They stated in the House of Commons that they themselves had seen prisoners with broken arms, swellings on their bodies the size of cricket balls, and scars on their necks. So let me turn to the European Commission case. As I noted, the European Commission had started work only in 1955. Most of its early work had revolved around petitions from individuals. This Cyprus case was different in that it was an interstate complaint. The first one was brought in May of 1956, charging the UK with the denial of nearly all human rights and fundamental freedoms, and alleging many cases of torture, degrading punishment, and inhuman treatment. As I noted, it originally included whipping, but that charge was dropped when the British authorities decided, under the pressure of public opinion, to remove that provision as a legal sanction. And then the more complicated charges of torture were taken out of the initial application and rolled into a second complaint filed in 1957. This first case then, which then eventually did not involve any charges of torture, was resolved in effect in Britain's favor, with the Commission ruling that the UK government needed to be able to exercise discretion in the context of the emergency. The second case, as I've already said, which does involve torture, does not get resolved. There is no Commission ruling, because it drags on into 1959 when a political solution is announced, and then both Greece and the UK agreed to terminate the case without resolution. And Greece, no doubt influenced in this by its desire, which is always pulled at it in this legal proceeding. It wants to maintain good relations with Britain in the context of the Cold War, while also taking up the cause of Cyprus. In the second case, then, the one that does roll together all of the torture allegations, it's whittled down to 49 cases where they believe they have the most evidence, the most convincing evidence of torture or maltreatment amounting to torture. Of those 49 cases, the subcommission delegated to investigate decides that 29 of the 49 are admissible. The other 20 not admissible because domestic remedies have not been fully exhausted. Now, when this first petition arrives in the Foreign Office in 1956, British officials are stunned. Historian Brian Simpson has written, nothing at all like the Greek application had ever previously been received in the Foreign Office, and there was tremendous consternation at its arrival. It was a shock because colonial governors and the military had relied on these techniques for as long as anyone could recall, and the notion that there were now international legal limits on what colonial administrators could do came as a complete surprise. Although it was only a few years since the UK had led the drafting of the European Convention, and 3 years since the UK had extended the convention to all but 3 of its colonies, in the colonial and foreign offices, the convention had essentially been forgotten. And in one 1958 document, when this issue is being discussed at Cabinet, it's noted that the real mistake appears to have been the extension of the convention to colonies. There's a strong sense of incredulity that comes across in the documents, an astonishment that the British reputation as a humane and civilized imperial power has not insulated its agents from criticism. And you can see this in this quotation, in which the British are saying they have this tremendous reputation for being humane and civilized, and how can it be that our police, who in the UK are lauded for their restraint, then become Gestapo types when they are in Cyprus? Totally, of course, ignoring the different context. And from their point of view, what they were trying to do was entirely laudable. They're trying to restore a proper respect for law and order. The Cabinet documents show a number of themes in the British response. First is a total lack of interest in establishing the truth of whether or not torture was occurring. Probably in part because of an assumption that it could not be anything like actual torture, but also because of a very strong sense that any kind of investigation, whether done by the British or especially by an international body, would undermine the morale of security forces. And indeed, public opinion, especially on the conservative side, was very much in favor of giving the security forces a free hand in repressing violence. There's also a sense that there's no realistic person who could reasonably expect the British to adhere to the kind of standard that the Greeks were demanding, and that it was only Greek political malice, not any kind of idealism or concern for the welfare of Cypriots, that was motivating Greek harassment of the UK. So the UK position was, first of all, to drag things out as long as possible, to argue that the complaints were inadmissible because of the Convention's requirement that domestic remedies be exhausted, and claiming that they hadn't been, and finally suggesting that the Greek complaint was motivated by politics and self-interest, and therefore was a perversion of the process. And also to deny everything. So in one public document, the UK forces in Cyprus stated that they rely on the worldwide knowledge of their traditions of humanity and decency to convince the public of the falsity of the allegations. They called the allegations an organized conspiracy, a fantastic illusion, filthy accusations, smears, and wild accusations. So how did they attempt to disprove specific allegations when these stalling techniques and denying techniques had run their course, and they were forced to contend with these 29 cases? Two things. They demanded an extraordinarily high burden of proof. To say if the Greek government were to prove that torture had occurred in any particular case, it had to have unimpeachable evidence. That was their argument. And then they provided counter evidence in the form of signed statements from British officials who were named as being involved. And those British officials simply wrote these statements in which they said, you know, I arrested so-and-so, I never mistreated so-and-so, sign. Now, in fact, the British did eventually come to see that there was a degree of substance in some of the cases. The very last stage of the case, before it's terminated, the number of torture cases being considered by the European Subcommission had been whittled down to 13. And of those 13, British officials acknowledged that there was a likelihood of a finding against them in 6 or 7. They said that it was almost certainly not the case that any of those were actually torture, but that there was a certain amount of rough treatment is their term. So,
Brilliant.
in this first interstate case before the European Commission, the UK was, in its own assessment, about to be found in violation of Article 3's prohibition against torture or inhuman and degrading treatment in up to 7 cases. Hundreds of cases of severe brutality amounting to torture had been presented in public and at the UN, but only the rare few with incontestable evidence, such as a doctor's report, noting that bruises or broken bones appeared to be the result of mistreatment, made it to the Commission's final consideration. So the case shows just how difficult proving torture was and how tricky the definitions of torture could be. Was a beating that left broken ribs torture? Was sleep deprivation torture? Was forced subsistence on too little bread and water, inducing painful thirst torture? Repression was continuing in Cyprus as the case progressed, and the costs of speaking out were potentially high on the one hand. On the other hand, a public propaganda campaign was being waged. How was it possible in these circumstances to make a determination of the facts, and what standard of proof should that determination rely on? These remain deeply contested and difficult questions. There seem to me to be 2 striking elements to this case that I want to bring out as I conclude. The first is how strongly the charges of atrocity resonated, and how much they resonated as atrocity thanks to the echoes of World War II. And this is perhaps different, although there are still echoes of World War II, as we heard in the last session, that torture comes to have different resonances in the 1960s. And it's really only in the 1960s that torture becomes the cause célèbre of the human rights movement. But we already see in the 50s the emotional power of individual stories of being brutally treated can have in the court of public opinion. And second, and finally, is that the way the Cyprus case shifts or begins to clarify definitions of torture in both law and public opinion under the new regime of international human rights laws. As the European Convention of Human Rights and Fundamental Freedoms and the Universal Declaration of Human Rights were tested in the real world, one result was a shaking out of rights into hierarchies, with some rights prioritized over others. In the Cyprus case, public reactions helped shape the second application's focus on torture, in a process that led to a red line being drawn around the concept of torture, such that it, and not inhuman treatment, again equally prohibited under Article 3, torture alone became the test of core values. And I'd like to suggest that this is not entirely a salutary development. In privileging torture so very far above inhuman treatment, human rights movements latched onto a powerful and emotionally resonant symbol. But definitions of torture remain deeply contested, subject to high barriers of proof. Inhuman treatment, again equally strongly banned, might have offered less problematic standards, both of definition and of proof. And by putting torture at the top, so very far at the top, of the hierarchy of rights, we seem to have conceded the battle in many ways against what is merely inhuman. Thank you.